Right now, if you'll turn to page 14, and we're going to talk a little bit about House Bill 2179. It's a pretty quick bill to go through. It goes into effect January 1st of '08. And currently, in DHS practice, if we have a child abuse report, we conduct an assessment. We can run a ledge check on people that we think may be alleged offenders involved in that child abuse report. However, we have to give them notice that we're going to be running a ledge check before we run the ledge check. When this bill is enacted, when this bill goes into effect, we can run the ledge check without prior notice. However, we have to notify them at some point after running the ledge check. So during the presentation of the bill and during the conversation during committee hearings, I think the legislature, they were trying to balance the due process and the rights of individuals versus the ability of the department to help protect children. And what rose to the surface pretty quickly was the fact that this bill, from the legislative point of view and from our point of view, will protect children because it will allow a worker to gather a little more information about what may be happening in a home before they actually go out into the home and do a CPS assessment. The other thing that it will do is we believe it will help protect workers. Quite frankly, if the workers know what they're about to walk into, they can set up for that and move into that. The legislature was behind this and supported it significantly. The only minor opposition was from ACLU, and actually they did not push very hard on this. I think they actually recognize this as a pretty reasonable thing to help protect children. So now I'm going to go to page 19. I'm going to take you all the way to the back of the document here really quickly. And the reason I'm going to cover House Bill 3113 and 3328, and these are two bills that really affect DHS and not so much the court system. So Timothy's allowed me to use some of this time to talk about this primarily for DHS staff. And House Bill 3113 is a bill that, according to the sponsors, and we agree with the sponsors, will help clarify what's currently in statute. And this bill now says that if there is a report of child abuse, and that child abuse allegation occurs in a daycare setting, in a child center facility, then DHS will conduct a CPS assessment and law enforcement will conduct a law enforcement investigation. So two things will happen. When the bill was introduced, we did a real quick survey around the state to see how things were handled. And of course, as most things, it was county specific. We were all over the map at how this was working. Assessments and or investigations were occurring, but it really was on a case-by-case basis, or the MDT had something mentioned in their protocol. The sponsor of the bill said that really left kind of a gap in a gray area, that if we didn't know clearly who was responsible to conduct an assessment or an investigation, that something could fall through the cracks. And even though we think that most of these were being covered, we have to agree with them that it did leave for some judgment in there. And because we have the cross-reporting law that's in statute, the sponsor said, well, let's just have both entities conduct what they're supposed to do. So when we receive the report now, it's cross-reported. Law enforcement will do their investigation, and CPS will do their assessment. And again, that bill goes into effect on January 1st. There were no, that we did not put a fiscal on this bill. We did not ask for additional resources for this bill. However, there was a policy option package that introduces a new staffing standard that will go into effect in January. And so if assessments do go up, and we're not sure they will, but if assessments do go up for DHS, there would be additional staff that would be earned because of those increase in numbers. With House Bill 3328, that bill went through the session known as Carley's Law, and that bill is currently in effect. And I just saw an email recently from Una Swanson, who's the point on actually both of these bills, and I know she's doing, I know she's written some draft rules, actually maybe some temp rules on this, and is out doing some training on this bill. I think even last week she was doing some training. But I want to talk about three things that the bill does specific to DHS. The bill says that if we receive a child abuse report and the report talks about a suspicious injury that occurs to a child, and we think that that suspicious injury occurred because of child abuse, that the department will take that child to a designated medical examiner within 48 hours. And so from a practice point of view, I want to mention that 48 hours mentioned in law is not a goal. We're not wait 48 hours to take the child there. It's just saying that within 48 hours we need to take the child to a medical doctor. I think one of the best things that I like about the direction this bill is starting to head is this is the first time since I've been in central office where I am seeing the legislature say, when you have a physical injury, DHS, you have a social work function and there is a medical function, and they're beginning to separate that and say, you need to take that child as a social worker to a medical doctor and work with that medical doctor as you work through your assessment. Use their expertise to help you with that assessment. So what we have been hearing, and we've actually talked to staff in the field that are implementing this law as it was written, most of the people are, when they're conducting their assessment the same day, taking that child to that designated medical examiner. I believe in the Portland area, I think you're using Caris Northwest, and there may be some other doctors identified, I don't know. The designated medical professional, and that's the term used in the statute, it's someone that's identified by your MDT. And most of the counties that have the assessment centers are using that as their base, and then they may be building on that as well. The other thing it talks about in the bill, the second thing I wanted to mention, it talks a little bit about photographs. In Carly's situation, and Carly's parents actually testified to a committee when this bill was introduced, and Carly died, and she was in another county other than Multnomah County. And a report of physical abuse came into the department and came into law enforcement. Both entities took pictures, and both entities lost those pictures. And the pictures that were taken were digital. And in working with the sponsor, there was a belief that we've moved from Kodak 3x5s into the digital world, and we're having trouble figuring out how to use the digital cameras. And I will raise my hand and say, I understand that. I got a digital camera last Christmas, and I can't tell you how many pictures I wished I didn't erase, but I did erase because of that little chip, and I thought I was transporting and actually deleting some of those things. So I can imagine what we were going through in the field when, in fact, digital cameras actually take quality photographs. So that it goes through to talk about some training that would take place at the local level. We're thinking maybe through your MDTs about how to take the pictures, who will take the pictures, and how those pictures would be preserved for evidence. So do you go back to the office and print it out immediately and then give it to law enforcement, or do you just give the chip over to law enforcement? That's something that you'll determine at your local level. But you have to have something in place in order to preserve that evidence if you have digital cameras. And I know the department is trying to get a digital camera for every CPS worker that we have in the state, and right now we have funding for one camera for 2 workers. So in your office, DHS workers, if you don't have 1 to 2, if you'll call Marge Reinhardt out of central office, we can get you that ratio of cameras. And as soon as we get some funding or find some resources, we'll help get the other cameras as well.
Is there a definition of physical injury?
There is.
There is. Suspicious physical injury.
Well, physical injury. Are we talking about the little bruise that...
No, it's defined. There's a whole list of definitions, but it's a very broad list. Suspicious injury, physical injury includes but not limited to burns or scalds, extensive bruising or abrasions on any part, bruising, swelling, or abrasions on head, neck, or feet. Goes on clear through dislocation, multiple fractures. So there's a whole list in the bill itself with regard to suspicious physical injury.
I think it may be in the rule as well, listed out in that. The other thing I'll mention about photographs is the bill is pretty explicit that if the injury is in the genital or anal area, that picture will be taken by a medical professional as opposed to a social worker or law enforcement. And just recently, we did have a district attorney raise a concern about that. And these two bills are being tracked pretty closely by the legislature. In fact, Una and I have testified on the implementation of them once, and we're due to go back next Tuesday for a second testimony. And what the chair said is they're going to be inviting the MDTs to the table in January or February to talk about the progress they're making with these bills. And I suggested to that individual, who was a district attorney, that they may want to bring that to the attention to the sponsor of the bill, who is also on the committee that's hearing these updates on the implementation, to have a conversation, because she is more than willing to make adjustments on this bill. She's very interested in this being a stair step to a better practice down the road. So there's plans for that sponsor of the bill to add to this in a very thoughtful, stepwise manner. The third thing I want to mention about the bill is it talks about the department conducting a CIRT, a CIRT, that's a critical incident response team, for us to do that process if there is a child fatality and we have that child in an open case with DHS, or if that child was open to DHS 12 months prior to the fatality. And the CIRT process is another one of those oversight mechanisms that we have internally, and we invite local staff and local partners who might have been significantly involved in the case. For instance, a district attorney and a CASA, could be some treatment providers, depending on the case dynamics. But to look at the case in great detail, come up with lessons learned, and then try to improve our practice through rule change or law change as a result of that. The other thing that the bill does mention for district attorneys is it invites district attorneys on any fatality in their county that occurs because of child abuse to send recommendations to the director of DHS and to the Attorney General at DOJ on how they believe, based on their assessment of that fatality review, how they believe they can enhance and improve child welfare practice. And Carly's Law is in effect now. I think I mentioned that before. So as you get, it's really around the physical injury piece of it. And in fact, I had to review a case for a constituent issue that we received, and in reviewing that, it was a physical injury, and it was a child that was age 3, and we actually held it up against Carly's Law to see if, in fact, we walked through it as it was written. And I was very pleased to say not only did we do that, but our partners in law enforcement actually followed the law as well. So we know it's being implemented, and you're doing a great job. So any questions about any of those 3 bills? Yes, sir.
You said that the critical incident response team was required if the agency had, I thought you said if the agency had custody in the last 12 months. But here it says was subject to agency protected assessment within 12 months. So does that mean if there was a call and we went out and investigated? Or what does that?
Well, I'm going to look to legal counsel for the details on that. I thought it was if we actually conducted an assessment.
You're right that it says the child was in the custody of the department at the time of the death. That's one. So that's the statute says you have to do it if it's an abuse or neglect is likely the cause of the fatality. If the child was in the custody of the department at the time of the death, or the child was the subject of a CPS assessment by the department within the 12 months preceding the fatality.
So there doesn't have to have been a court case open necessarily.
No. And that's what DHS is currently doing is most of the certs, I mean, they're looking at doing critical incident response teams on children if there's a fatality and there had been a CPS assessment within the previous 12 months.
Yeah, and I will say this about this bill. The sponsor of the bill worked very closely with DOJ and DHS on the language, and the idea was to try to keep it as close to current practice as possible, just to get it into statute and build on it and begin to enhance that quite a bit. So, great.
I have a question.
I'm sorry. Yes.
Will there be any attention on closed screenings in the last 12 months?
No, I don't think so. I don't think closed screening would be. Does that sound
Well,
right?
I mean, a closed screening is not, is that a situation where the child is subject to a CPS assessment?
Yeah.
That's what
I
the
just wonder if
statute
there's any
says.
attention that will, I mean, if that would engender any attention.
Well, not in this bill, but that's a good question for something that might be dealt with down the road. I can't say that there is or isn't at this.
And again, this sets the threshold. I mean, DHS must conduct a cert here, but I think under DHS's cert practices or policies, DHS could actually initiate a cert on another case, but, so this sets the minimum that DHS must do.
Yeah, I think part of the conversation that I recall when we were working the language out on the bill was the bill sponsor is always very sensitive to that fiscal impact, because if the cost of the bill goes up too high, it won't pass at all if there's no resources. And as session begins to roll out and money is spent, or theoretically spent, then they run out of money. And so if it has too high of a fiscal, the bill won't even pass. And so there was a lot of compromising that went on to keep the fiscal impact of this bill very, very low so that it would, in fact, pass. So what you're asking, my immediate thought is, might have a fiscal impact, to create, some additional workload. And if that's the case and money is put into it, then yeah, that might be a concept and a direction that the bill sponsor would like to go. So thanks. Sure, I can do 413. Yeah, Senate Bill 413. That I can actually go through that one pretty quickly. This bill does not affect you at all. So that's it. But we did put it here. We did put it here for a reason. Senate Bill 413 is a bill passed by the legislature that requires the department to make interim reports to a legislative committee based on certain data that they would like to see. And when the bill was first drafted, there was, I'm guessing, maybe twice as much data that was requested by the bill sponsor than what actually passed. And it was some of the data, I mean, it all was good data, for them to have. But the problem was our database system didn't pull it out easily, and so there was going to be a pretty large fiscal impact. So what we did was we said we can gather this information now, so this would have zero impact, and that's what we ended up with, that set of data. But the legislature is very interested in us coming in November, just before legislative session, and doing a report on the data that currently appears in the Status of Children report. So for community partners, that's a report that we do annually. It's online, and we usually put online the last 7 or 8 years, so it's quite a bit of information. What I understand is there's 2 or 3 pieces of data that doesn't currently appear in the Status of Children report, and next year we're going to revise that to include that, so that we will in essence be delivering the Status of Children report as a report to the legislature in November. And I think this is one of the reasons we wanted to put this bill in your packet and talk about it is I think this is pointing to the ongoing interest the legislature has in helping the department improve child welfare services, because they are now asking in statute for us to come in front of a committee before session begins and report on certain outcomes, certain data that we have, so that they can begin to ask questions and formulate what the next step would be to help us improve our practice.